welcome everyone. It's great to see so many attendees. For those who don't know me, my name's Emma Brooksbank. I'm head of our national immigration team here at Freets. And today's session is the second of two webinars covering the immigration rule changes, which were forwarded in the white paper of the 12th of May and then published into rules which were provided on the 1st of July and which will be implemented on the 22nd of July. Now, today's webinar is specific to the care sector. We will cover some of the general changes, but there are some quite significant changes directed at the care sector. So we felt that it would be helpful to provide yesterday's webinar, which gave a really good overview of the changes as a whole, and then today to really tailor it down to your sector. So if you're on the webinar and not in the care sector, you're very welcome to stay on the webinar, but you may also benefit from receiving the recording from yesterday's session, which we can arrange to send out to you if you ask us for that. So the way that it'll work today is we'll spend about 25-30 minutes running through all of the key changes, discussing the impact on care sector businesses, looking at some of the kind of practical tips and steps, things you might want to be thinking about now, and then looking to the future and just have a think about what comes next. You may have questions throughout the session. If you do, please put them straight into the Q&A box. We will be picking them up immediately after the session and we will respond to you directly. That just means that we can really tailor our responses to your question and to your specific business requirements. If you have questions following the session, something that you wish you'd asked, forgot to ask during the session in the coming days, weeks and months, please feel free to email the immigration team at Freets. Ashley, my colleague, will be putting the email address into the chat. It's reasonably straightforward. It's immigration@freets.co.uk. You'll also see that Ashley will be putting in some useful resources during today's session, which you can then copy the links for and have a look at in your own time. So she'll be providing you with the white paper itself to give you an idea of direction of travel and various relevant articles and resources that we have published to give you an overview of what's happening and what's still to come. Additionally, immediately following this session, we will provide you with the slides and the recording and some further useful resources. So when we'll be talking about occupation codes, which are no longer eligible for sponsorship, we will provide you with a list of those. We'll be talking about a salary list, we'll give you that. We'll be talking about a temporary shortage list, and we will provide you with that. You can expect to see those coming into your inbox in the early part of next week. Okay, so I'll make a start. So if you could move on to the next slide for me, please, Tom. Thank you. So I mentioned that this first tranche of rules have been published and that they will be implemented on the 22nd of July. So that's a crucial date for your diary. What that means is that any certificates of sponsorship which are assigned between now and including the 21st of July will have the old rules apply to them. Any certificates assigned on the 22nd and beyond that date will have the new rules. So if there are circumstances where it would be beneficial for the old rules to apply, and if you have the certificate in place, you might want to be looking at that, looking at what's in your pipeline and just considering whether it is possible to get those assignments through before the rule changes, and then you'll have a period of months to deal with the visa application. So the crucial point is certificate of assignment, and the crucial date is the 22nd of July. Next slide, please, for me, Tom. Thanks. Okay, so what's changing? Well, for the care sector, the really big headline change is that entry clearance applications will no longer be accepted under the new rules from 22nd of July. So these are applications made by people who are overseas at the time of the application. So applications for sponsorship and visas will only be permitted from within the UK, and you have two key groups of people who will be able to make those applications. The first will be candidates who are currently on a different visa route. So they might have a graduate visa, they might have a dependent visa, they could have a variety of different types of visa. They're currently on a different visa route, and they're looking to switch into the skilled worker route in a care role. And I'll mention care roles a few times during today's session. And when I'm mentioning care roles, I'm talking about SOC code 6135 for care workers and SOC code 6136 for senior care workers. Okay, so you may have people with existing visas who are looking to switch. If you, in that situation, they will have to have been already working for the potential sponsor for a period of 3 months prior to the assignment of their certificate of sponsorship, which they will use for their switching application. And under the rules as they will be, they will only be able to do that up until the 22nd of July 2028. So we've got this 3-year period during which that provision applies. Additionally, you will have candidates who are already sponsored in a care role. So they already have a skilled worker visa in a care role, and they will be able to make a further application for sponsorship in a care role. Now, it might be that they're already employed by you and they're looking to extend their sponsorship. You're looking to extend their sponsorship. You want to continue to employ them. They will be able to continue to do that. Or they might be employed by a different employer and they're looking to move to you. Provided they've already got their skilled worker visa, then they would be able, you'd be able to assign a new certificate to them, and they would be able to use that to apply for a new care role, skilled worker visa, to then come and be employed by you. Next slide, please, Tom. Thank you. Now, we have for a short period of time had this requirement to look to the pool of displaced care workers to check whether there's anybody available in the location in which we're recruiting before we could consider securing a defined certificate of sponsorship and sponsoring somebody from overseas. Because the provision for sponsorship from overseas is coming to an end, it's considered that there is no longer this requirement to look to the displaced pool first. So that will come to an end. There's a small change to SOC code 6131 for nursing auxiliaries and assistants. The Home Office was concerned that that occupation code could be misused in a care setting, and so they refined the definition of that code to require that it is only used for a role in an environment where a registered nurse role also exists. Next slide, please. Thank you. Okay, so the really big headline for these rule changes is a change to skill threshold. So under the existing rules, you can sponsor into occupations which are A-level level or above, or which are on the immigration salary list. The change which is being implemented is that we will only be able to sponsor into roles which are at graduate level or above. And so that is what we call RQF 6. So all the RQF 3 to 5 roles are being removed from eligibility for sponsorship unless a person is already sponsored in a 3 to 5 role and they are continuing to be sponsored as a skilled worker. That's permitted. Or, and significantly, unless a role at RQF 3 to 5 is either on the temporary shortage list or on the immigration salary list. So I wanted to explain both of those in a care context so that you can get a feel for how that applies, because you will be aware that care roles are not RQF 6 roles. They're lower than RQF 6. Okay, so the temporary shortage list is a new concept. It will be introduced under the new rules from the 22nd. And this list contains RQF 3 to 5 roles, but only roles that have been identified in the UK's modern industrial strategy as being vital for UK economic growth. So what you'll find in the industrial strategy are 8 sectors which have been identified as important for growth, and corresponding roles on the temporary shortage list which align to each of those sectors. So, for example, the sectors include business and professional services, creative industries, advanced manufacturing, clean energy, defence, etc. Now, what you won't find on the temporary shortage list is any health occupations, no dentistry occupations, and no care roles. So we need to for our purposes, put the temporary shortage list to one side, but then recognise that the immigration salary list is not being replaced. It will still run alongside the temporary shortage list. So the immigration salary list is what used to be called the shortage occupation list. We're familiar with that. It is the existing structure under the rules as they are now, but the immigration salary list will be expanded to some of an extent. So it'll be expanded to include all of the occupations that MAC, the Migration Advisory Committee, recommended to be included in their 2023 and 2024 review. And the end result is that you will have a list with about 25 occupations listed on it. And importantly, and the reason I'm telling you this, is that it will have the care roles listed on it. So it will have 6135, will have 6136. And the benefit to being on the immigration salary list is that there is a lower general threshold applied to roles on that list. And we'll look at salary in a moment, but you'll be aware, I think, that we look at the general threshold, which is like a baseline, and then we'll also look at the going rate for the role. There's no discount to going rate on the immigration salary list, but there is a lower general threshold. And for our purposes, for a health and care role, which relies on ASHA data as care roles do, that lower salary on the immigration salary list has been retained at 25,000, but we'll look at the detail in a second. Important, just for reference, one of the important changes being brought in with the introduction of the temporary shortage list is that people who are sponsored on that list will not be able to bring their dependents. And also importantly, both lists are intended to be time limited. So temporary shortage list have occupations which will lapse on the 31st of December 2026, and the immigration salary list has occupations that also lapse on that date, but care roles lapse on the 22nd of July 2028. So that's that 3-year period from implementation dates at 22nd of July 2028. And the intention is that the list will then be phased out once there's no longer any roles. But we'll have to wait and see, because in immigration, many things will change between now and then. The government's reserved the right to bring those deadlines forward, but equally, if there's other pressures applying, those deadlines may be pushed back, or there might be further overhaul of the immigration system. But as it stands at the moment, that's the expiry date of the immigration salary list. Next slide, please. Thank you. So this is where we just look quickly at salary. So across the board, the general threshold, that baseline, is increasing to 41,700. There are still discounted salary rates for PhD holders, immigration salary list occupations, and new entrants, people transferring from student and graduate. But importantly, and I've highlighted in pink there on the slide, health and care ASHA salary roles have a lower rate to start with. Okay, so their general threshold is 31,300. But then, because you're on the immigration salary list, that's discounted even further, and that's how you get to 25,000. So 25,000 is what you'll be familiar with. There are increases in salary for most occupations, but not for care roles. So it is the 12.82 per hour that you're currently familiar with. 25,000 on a 37.5-hour week is 12.82. Any other working patterns have to be prorated, so it will always be 12.82 or higher. For care roles, the going rate is also set at 25,000. So while usually when we're looking at salary, we have to look at both thresholds and see which one's higher. For care roles, they're both 25, and so we know that we're fine on 12.82 per hour. Next slide, please. Fantastic. Just a quick mention on dependents. There hasn't been a change, but it's just a quick reminder. Dependents are not permitted, haven't been permitted since March 2024. However, if you have skilled workers or you're recruiting skilled workers who have held leave to remain in the skilled worker category in a care role at all times since prior to that date, and they have dependents accompanying them, then those dependents can continue to accompany the main skilled worker. There's also a couple of exemptions from the prohibition on dependents, and those are for children born in the UK to a skilled worker, and children whose parent has sole responsibility for them, or who is their sole surviving parent. Next slide, please, Tom. Thank you. So I think it's helpful in these sessions to give you the law, to tell you what's changed, but then also to give you some recommendations about how this is going to impact your business and what you might want to be taking away with you from today's session to speak with your HR professionals or your recruiters or payroll, whoever it may be. So do have a look at your current workforce. Have a look at whether you have any current entry clearance matters, proposals, applications in the pipeline. If you have an existing application, so a visa application which has been submitted, that will be fine. That will be processed under the existing rules. If you have a matter where you've been granted a defined certificate of sponsorship, then there's some pressure on you to make sure that that is assigned before the 22nd of July deadline, because beyond that date, entry clearance is no longer permitted. In reality, I'm a tiny bit hesitant about recommending that you pull out all the stops to try to push through any other entry clearance matters, because it will probably be very difficult to get a allocation of DCOSs now between now and the 22nd of July, if a DCOS hasn't already been granted for a proposed candidate. Now, that's not to say that you wouldn't try, but I think it will be very difficult if that DCOS isn't already in place. Do also bear in mind that the sponsor management system will probably be shut down in the 24 or 48 hours prior to the implementation of the rule changes, just to ensure that any changes that need to be made to the system can be made. But that does mean that the opportunity for last minute assignment of certificates is quite limited. So, as I mentioned, we will be sending the temporary shortage list and the immigration salary list out. You can also look at the immigration rules to access those lists and to access the most up-to-date version of the lists. If you're looking at the lists and thinking, yes, we do have a plan to recruit into these roles, then just bear in mind the expiry date. So the deadline of the end of 2026 and then July 28 for care roles. And when you're looking at your future planning, plan that deadline in, but also be aware that that deadline might be brought forward. So any recruitment plans are probably best implemented sooner rather than later. Not as applicable to care roles, because we don't have significant changes to salary, but moving forwards, do keep an eye on the general salary thresholds and the going rate, because we can anticipate that these will continue to increase. And if they've increased, then you need to plan in those increases for your cost planning. When they increase, you don't then need to immediately increase the hourly rate for sponsored workers who are already employed by you. The increase needs to be implemented at the point at which a new certificate of sponsorship is assigned. And I'd also recommend that you have a think about whether there are any training requirements, whether you need to update HR, recruitment, payroll, any internal comms that need to go out around these rule changes. Next slide, please, Tom. Thank you. So we've had the white paper, which gave us a framework, a statement of intent in terms of changes to the immigration system during this year. Some of those changes are now being implemented with the statement of changes that we've been discussing today, and with the changes that are coming in on the 22nd of July. But as they were announced, the government also indicated that these elements of the white paper proposals are still in the pipeline and are intended to be implemented by the end of this year. So that is the raise to the immigration skills charge. Just to remind you, that will be increasing by 32%. So again, as a continuation of the general theme, if there are matters that you're thinking you will be dealing with in the future, it might be better to deal with them sooner rather than later to avoid any adverse rule changes, but also to ensure that you're paying today's immigration salary charge rate rather than the higher, which we know will be implemented later this year. There will also be changes to the language requirements across the immigration system, which are yet to be fully published, but we do know that those will come in. And then we'll have the unveiling of a new family policy framework to Parliament. Interestingly, nothing in the announcement flagging the future changes about the proposal to change the settlement qualifying period from 5 years to 10 years. Now, that may mean that it's been put on the back burner. More likely, it's just that it needs primary legislation and that those plans haven't been fully formulated. So more likely that we'll hear more about that later in the year. Next slide, please. So that's everything I think that you need to know about the imminent rule changes. So it just leaves me and the team to say thank you very much for attending. If you would like the recording from yesterday's session, which has a more general overview, then request that, or if you were registered for yesterday's session as well, you will receive that. You will receive the recording from today, you will receive the slides, you'll receive the resources that I've mentioned. I can see that there's some questions in the Q&A, so Ashley and I will be picking those up directly with you today. And as I mentioned, if there's anything else playing on your mind that you're concerned about and you're not sure how it's going to work in practice that comes up in the coming days and weeks, please just send us an email. We're always very happy to help. And that email address again is immigration@freeths, freeths.co.uk. So thank you for attending. Enjoy your weekend, enjoy the sunshine, and hope to speak to you soon.